So the third thing involved with children is child support. So when you filed the complaint, you did a child support affidavit, and that lists what you make for money on an annual basis. And then in response, if you're a defendant on a case, the court's going to ask you, when they send you the date for your case management conference, they're going to ask you to fill out a child support affidavit, and so then you're going to give the information about what your annual income is. And then the state of Maine has specific guidelines for what child support should be based on what both parents make. So parent A may make $10,000, parent B makes $20,000. That's $30,000 altogether. You look it up in the chart and you see what 30 is, and then the parent making twice what the other parent is going to pay more of that child support number. It's a number. It's a computation that if you go to Pine Tree's website or helpmemaine.org's website, they have the actual form online, and it will calculate for you. So you don't have to do any of the calculations yourself by hand. It's also going to include any daycare costs or health insurance and dental insurance costs for the children. So that number, again, typically the court's going to go with guideline support. You can go up or down. You can deviate from guideline support if there's a very good reason, or if there's an agreement between the parties. Or if you prove to the court that guidelines would not be reasonable or just. But for the most part, usually guideline support is what's going to happen. So that's basically the kid issues, just really basic kid issues. The court will likely order or suggest that you go to what's called the Kids First program, and that is a 4-hour program on a Saturday where you learn about what your child is actually going through while you're going through your divorce, and what to say and not to say to your child. Because I think because a lot of times when parties first separate, there's a lot of animosity, and sometimes the kids get in the middle. So that's one thing that the court wants to make sure that's not happening. So if in your case there is some animosity and you think the children are being talked to, be sure to mention to the magistrate, if they don't mention it to you, that you would like both of you to attend the Kids First program. You don't attend on the same day if you don't want to. In fact, they encourage you not to attend the same day. So it's just a good program to go to. So the other issues, if you're just doing a parental rights case, those are the only issues that your court is going to be able to deal with. They're not going to be able to deal with if you're living in the house together, even if you own a house together. If you're not married, the court can't do anything about that. That's going to have to go through a different court unless you agree to something. You're going to have to go through a small claims court or superior court. You have to go elsewhere for that. When it's a divorce, the court's going to is going to divide your property, divide all marital property. Now, there's marital property and there's non-marital property. The court considers all property that you own right now to be marital, but there is property that you can prove is non-marital. So for instance, if you owned a home prior to getting married and you still own that home separate from your marital home, that may well be a non-marital asset of the marriage that might not be put into the whole pile of marital assets. It's kind of convoluted. You can make a lot of arguments either way, but for the most part, everything's going to be marital unless you can prove it's not marital. And when you talk about property, you're talking about real estate, obviously. You're talking about personal property, household furniture, clothing, excuse me, vehicles, ATVs, ski mobiles, things like that. All of those kind of things. And you're talking about bank accounts, retirement accounts. So in the state of Maine, the state of Maine is an equitable division state, which it's not equal, but it's equitable. Most of the time that means equal, but sometimes it doesn't. But so the court's going to look at all your assets and all your debts, and then try to divide those as fairly as possible. There is one more issue of financial information when we talk about spousal support, which some people call alimony. The state of Maine calls it spousal support. And there's no formula like child support for spousal support in the state of Maine. So I find that every lawyer, every judge does it a little differently, but basically it's, again, you can get into the situation where you're in the state of Maine. If you've been married for 10 years or more, the court presumes that you're entitled to some kind of spousal support if you're the lower income parent. There's a presumption. You can overcome that presumption if you've been married for less than 10 years, or if you're the parent who's being expected to pay, you can overcome the presumption by saying that there's not enough money for spousal support. There's not always enough money for spousal support, especially once child support is paid. Sometimes there's just not enough. The parties are already at equal amounts, or one party's taken on more debt than the other party. There's a lot of different factors to go into spousal support. But that's just that's another issue that it would be addressed in your mediation or at your final hearing. I will say that the courts want you to settle things on your own. They don't want to make any decisions for you because they don't know you and they don't know your children, and they don't know anything about your lives really. They're coming into your lives, 3 or 4 hours at a time, and you're the best judge to decide what should happen with your children and what should happen with your property. So the process in the court will, again, you have your first case management, and then you'll go to mediation. And so, excuse me. Before you go to mediation, if you're going by yourself, it's really important that you want to make a list of the things that you want, and separate it out between kid issues and the financial issues. So you put down for the children issues, you're going to put, okay, do you want primary, or are you willing to do a shared? What kind of schedule, even if it's primary or shared, what kind of a schedule is the other parent going to have? It's important to put down holidays down there. What holidays are important to you, and how do you want to share those holidays? Do you want to alternate them year to year, or do you want to share the holiday on the actual day? There's a lot of different ways to do it, but write all that down and have that ready. Your mediation is usually about 2.5 hours. What the courts in Portland at least have been doing now is they schedule you for a status conference right after your mediation. So you have about 2.5 hours to actually mediate, and then you go into the court to tell them where you're at. So if you have a list of things with you, and you know what you want to talk about, it's going to be that much easier to get through the mediation. The other thing is you have 2 shots at the mediation. Mediation is $80 a person, and again, you may be able to get that fee waived at the beginning of the case. And even if you don't get the fee waiver granted at the beginning of the case, ask the magistrate again and explain your circumstances and see if she can waive the mediation fee for you. So, I lost my train of thought. Mediation. Sorry. So you bring all your you have the 2.5 hours, and then you have the opportunity for a second mediation for that same $80. So you get 2 shots for the $80, or again, if you get the fee waived. So even if you don't get everything settled in that first mediation, if you're making progress, just let the magistrate know you're making progress, you want another mediation. If you're not making progress and you don't think it's going to go anywhere, then explain that to the magistrate. They've seen this, they've heard it before. They'll know how to direct you. They might even have suggestions for a way for you to figure out the issues without having to come back to court. And then once you're done with mediation, if you're totally done with your mediation and you've come to agreement on everything, the court will put everything on the record. And usually if there's not attorneys involved, the court will draft something up that's based on what you're saying on the record, and that's your final order. And as long as if it's a divorce, as long as it's been 60 days since date of service, you can be divorced that day. Parental rights, it doesn't matter there's no 60-day waiting period. so you can get the parental rights judgment whenever you're ready, and the court can put it on the record, and you're done. If you don't think you have an agreement, but you think that you might come to an agreement, you can ask for a further status conference in 30 days, or you can ask the court to pre-try it. And what pre-trying means is you're going to be put on a trial list, which is probably about 2 months out. It depends on the court. And you're going to have a final hearing at some point. So you're telling the court how long you think that hearing is going to be, what the issues are going to be, because you may have resolved some of the issues. So what the issues are going to be. And then how many, who do you think you're going to call for the witnesses, and also if there's going to be any experts testifying or anything like that. And so then the court's going to put you on a trial list. This does not mean you need to go to trial. I have some people come into me and ask me that question. If we're on the trial list, do we have to go to trial? No. Again, the court wants you to do everything you can to settle this case on your own. So up until the day of that hearing, you can try to work it out. You can mediate on your own. You can get a private mediator. You can just send back proposals back and forth. If you are going to court and you don't think you have an agreement, again, much like you did in mediation, write down for the court what it is that you're asking for that day. Because if you have to have a hearing, the court's going to want to know before it goes in to hear your case what exactly you're asking for. So then the court will know what to concentrate on when there's testimony. So that's a very important part. At all steps in this process, know what it is you want. Also know what it is you'd be willing to compromise to, because the nature of divorce and family law in the state of Maine is compromise. And any judge will say to you, you're not going to get everything you want. She's not going to get everything she wants. And you're going to meet in the middle somewhere. The judge is going to meet you in the middle somewhere anyways. So if you can do that yourself, it's better. So I always tell people what I know what you want. Here's your wish list, but what would you settle for? And that's just the nature of compromising in a divorce, because we're talking about usually children here and personal property, and it's a very emotional process for most people. But what you can live with to move on to the next step, I think, is important. Do you want me to talk about spousal support? A little bit about the different kinds. Okay, I'm just going to briefly speak about spousal support. Again, that's alimony. There's 3 kinds in the state of Maine. There's general support, transitional support, and reimbursement support. Again, general is usually if you've been married for more than 10 years. And also I should clarify that if you've been married between 10 and 20 years, the presumption is that spousal support, if money's available, would be paid for half the length of the marriage. After 20 years, the statute is silent, but we lawyers kind of assume that means that, okay, it just goes on forever, or it goes on to usually what we do to retirement age or something like that. So that's just something to know. So that's basically what general support is. And then there's something called transitional support, and sometimes that's given to someone who has been married for less than 10 years. It can also be for someone who's been married more than 10 years. But maybe they've been a homemaker, and they haven't been out of the house, so they need to go to school, or they need to start working part-time and work their way up to getting a full-time job. So there's something called transitional support. It's usually there's usually less time period of it than it would be for regular general support. And reimbursement support is, had they, did they do something during the marriage that they should be compensated for now? Did they, help pay your school fees or something like that? So there's a number of factors the court's going to consider for spousal support, including the length of the marriage, like we discussed, the ability of either person to pay, and again, not always just because you've been married more than 10 years means there's an ability to pay spousal support. Employment history, age of the parties, health of the parties, any kind of economic misconduct on either part of the parties, and tax consequences, and anything else that the court feels the need to consider. So again, it can be a complicated concept because there's no formula for it. So if you do have a spousal support question, it might be easier to have that heard at mediation or maybe a settlement conference. That's the other opportunity you have instead of having a final hearing or before a final hearing, you can ask the court for what's called a settlement conference. And what that is a mediation, but it's a mediation with a judge or a magistrate. So you're not just talking to, you're talking to a judge and a magistrate who has actually decided these cases and seen a lot of the same topics and stories that you're experiencing in your divorce. So they're going to be honest with you and listen to the facts of your case and be honest and say, well, if I were deciding this case, this is how I would do it. So you're really getting the court's position on, this is what's going to happen if you go to court. Why go to court? Now, if you don't come to an agreement at that settlement conference, that same judge can't hear your case. But it's a really good process if you're having difficulties with your, the other party, and maybe there's just some unreasonableness in what's going on. And you can get them to maybe if a judge or a magistrate talks to them, it might be a little easier. It's important to go to all your court dates. If you cannot make a court date, make sure you let the court know. Make sure you tell the court if you can't make it and it needs to be continued, that you tell them why you can't make it. Maybe you have a doctor's appointment or something. You have to file a motion to have it continued. It's very important when you're there, just to be respectful of the court, even if your soon-to-be ex is not being respectful, and you want to make sure that the court always has your current address on hand. So if you moved halfway through this process, that they need to know how to get in touch with you. The other thing is, if there's a case of domestic violence in your divorce or parental rights action, and you do not want your address to be public, there is a form that you can fill out at the clerk's window, that will keep your address confidential, and only the court will have that information and nobody else will have